Hello. Anong araw ngayon? It's Wednesday, April 29, 2020, 8 p.m. So, dito tayo sa RFPT, partnership topic. So, fast track lang to. Kasi kulang tayo sa time. Pero madali lang naman tong partnership. So, ano ba tong partnership? Well, general provisions tayo. Partnership is governed by the new Civil Code of the Philippines, kung saan nasa Title 9 siya. And ito yung definition ng partnership according to Article 1767. Ang partnership daw is by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. And two or more persons may also form a partnership for the exercise of a profession. So as we can see here, which we will discuss further, yung mga requirements ng partnership na dapat may two or more person. Of course, hindi yan partnership kung hindi at least two persons ang kasali dyan. And dapat daw may contribution ng pera, may contribution ng property, or kahit man lang industry, which is yung services mo or yung expertise mo into a common fund na kung saan the reason bakit kayo pumasok sa contract of partnership is to divide the profits among yourselves. Now, dito naman, as we can see, kahit the exercise of profession lang, pwede pa rin mag-form ng partnership. Like for example, yung mga auditing firm, mga law firms, yun sila, mga exercise of profession lang. Now, ano mga characteristics ng partnership? What kind of a contract is partnership? First is that it is consensual kasi it is perfected by mere consent. Ito lang, generally, ito lang kailangan meron ng partnership. Second is nominate. Meron siyang designated name. Kasi alam natin yung mga designated name, yan yung kasi alam natin yung mga nominate, yan yung mga kinds of contract na binigyan ng pangalan ng batas. They are given name by the law. And in this particular topic, the contract of partnership is provided by Title 9, Article 1767 of the new Civil Code of the Philippines. Kaya it has a designated name, and that is contract of partnership. Third is that preparatory. Its formation is allowed by other contracts to carry out its purpose. Itong preparatory pa lang, ito yung magiging prelogue or ito yung magiging starting point na kung saan the partners can enter into other contracts such as contract of sale, contract of leasing. Preparatory siya kasi kailangan ito para maka-enter sila into other subsequent contract. Fourth is that it is onerous because it involves consideration. Hindi sa gratuitous, it involves onerous kasi may equal exchange of consideration. Or not necessarily equal but deemed equal. Kasi alam naman natin yung onerous, kailangan kung may bigay ka, meron kang the same value na ma-receive. In this particular circumstances, nag-contribute ka sa mutual fund, and yung consideration na matatanggap mo is yung nakapasok kayo sa isang partnership na kung saan ang purpose is to divide the profits among the partners. Fifth is that it is bilateral or multilateral. Bakit? Entered into or stipulated upon by two or more persons. As we can see, it is a partnership. Hindi yan sa sole proprietorship. So meaning yan, dapat may at least dalawang taong kasali sa contract na yan. And lastly, it is a principal. It can stand alone. Hindi niya kailangan ng other contracts just to support itself. Now, ano bang mga elements ng isang partnership? Well, ito nakita natin as nakalagay dito sa article ng definition ng partnership. First element is there's a meeting of minds. Meaning, nagkasundo yung mga partners, nagkasundo yung mga party na magtatayo sila or mag-start sila ng isang partnership. Second is to form a common fund. Meaning, magbibigay sila ng kanya-kanilang contribution sa isang common fund. And bakit? Kasi from that common fund, yan yung gagamitin nila to start or operate their partnership. And third, with intention that profits and losses will be divided among the contracting parties. Ito yung reason bakit sila at the first place pumasok sa isang partnership para magkaroon ng profits, for which those profits will be divided among themselves. Now, ano mga essential features ng isang partnership? Well, Lima sila. First is there must be a valid contract. Siyempre, it is a contract of partnership. Kapag hindi valid ang contract, hindi valid ang partnership. Second is that the parties must have legal capacity to enter into contract. Kasi pag incapacitated yan sila, as the law provides, hindi yan sila makakapasok sa isang contract. Like yung na-discuss natin sa obligation and contract, magiging voidable yan or magiging unenforceable depende sa incapacity ng mga parties. Third is that there must be a mutual contribution of money, property, or industry to a common fund. Ito kailangan. Kasi that common fund, dyan nila, gaya ng sabi natin, kukunin yung mga bagay na gagamitin nila for the operation of the partnership. Fourth is that there must be a lawful object. Ang lawful object na minimin dito is yung capital na kinontribute or is basically the capital of the partnership. Kapag hindi lawful yung capital na yun, kapag hindi lawful ang object na yun, well, the partnership itself is unlawful. Fifth is that the purpose or primary purpose must be to obtain profits and divide the same among themselves. Now take note, it is also required that the articles of partnership must not be kept secret among the members. Otherwise, the association shall have no legal personality and shall be governed by the provisions on co-ownership. Because as we know, the partnership or a partnership, pinasukan niya ng tao kasi alam niya kung ano ang mangyayari dyan. Now, if you will keep him in the dark, if you will keep him from knowing the things about the partnership, parang ginago mo yung tao kasi wala na siyang equal footing on that partnership. In-isolate nyo. So, hindi na siya matatratong bilang isang partner. Okay, pag ganun nangyayari, wala na yung legal personality ang association na yun, ang partnership na yun. Kapag ganun nangyari, treat sa kanya is co-ownership. Now, ano ang form of partnership contract? May kailangan bang special form? Kailangan ba sa oral? Kailangan bang nakasulat siya sa papel? Or pwede kahit sa dahon lang? Well, general rule, according to Article 1356, no special form is required for the validity of a contract. So, since a partnership is a contract between two persons, generally, hindi na kailangan ng special form. Meaning, kahit oral lang na, pasok tayo sa isang partnership, mag-contribution tayo, etc. etc. Okay na, kahit oral lang. Kaso, yun yung general rule. So, alam natin kapag may general rule, mayroon tayong exceptions. Now, anong mga exceptions na yun? First is, kapag immovable property or real rights ang kinontribute according to Article 1771. Now, kapag gano'n nangyari, kailangan mayroong public instrument. Usually, Usually, yan yung registry of deeds or yung mga pinanotary mo. Kasi pag pinanotary mo yan, magiging public instrument na yan siya. And another requirement, kapag ganun, is that the inventory of the property contributed must be made, signed by the parties, and attached to the public instrument. So, yun. Ito yung kailangan mo kapag immovable property or real rights ang magiging contribution to the common fund. Now, kapag hindi mo to na-satisfy, boom, void. Pag void to, void rin ang partnership. Kasi, as you can see, hindi na siya lawful object. Kasi hindi nyo finalo yung special form. It is already unlawful. So, public instrument and inventory of that property kapag immovable property or real rights ang i-contribute. The second exception is when the contract falls under the coverage of the Statute of Frauds. Na alam ko, familiar na tayo dito sa Statute of Frauds as provided by Article 1403 of the New Civil Code of the Philippines. Kung matatandaan nyo, mga sample ng Statute of Frauds is kapag yung lease is for more than 1 year or kapag sale of properties. Another is kapag yung action to take in a contract is more than 1 year. Another is yung credit representation sa third person. Another is yung guarantee na kapag hindi nakabayad tong taong to, ikaw ang sasalo. So, yung mga sample lang yun ng Statute of Frauds. So, kung gusto niyo mas clear na, ito, Article 1403 of the New Civil Code of the Philippines. And number 3, last exception is that kapag yung capital is 3,000 pesos or more, in money, man, or property according to Article 1772. So kapag yan daw yung contribution, public instrument is necessary and it must be registered with the Securities and Exchange Commission. Now, recommended is dapat greater than 3K. Huwag mo isakto dito kasi para less ang problema, sabi ng reviewer. Now, as you can see here, parang with these exceptions provided, parang mas naging general rule pa to kaysa ito. Kasi ito, no special form is required for the validity of the contract. Pero yung exceptions, basically ito yung mga needed ng isang partnership para makapag-operate. So parang wala silang choice but to provide this para makapag-operate sila at least conveniently. So yan ang form of partnership contract. Now, pumunta naman tayo sa separate juridical personality. Now, ano ba tong juridical person? It is basically as a legal person. Hindi siya natural person, hindi siya tao, hindi siya natural person, but rather it has a legal personality. Its legal personality, its existence is created by operation of law. Batas ang nagbigay buhay sa kanya. Kaya tawag sa kanya is a juridical person. Now, juridical persons also have their rights and duties provided by law. Now, gaya dito, ito yung mga rights and duties ng isang juridical person. A partnership may acquire and possess property of all kinds. Second, incur obligations. Pwede siyang magkautang. And third, bring civil or criminal actions in conformity with the laws and regulations of their organization. So as we can see here, may separate personality, separate juridical personality ang isang partnership, separate from its owners, the partners. Parang corporation din, separate legal personality from its owners, the stockholders. And as we know, now as opposed to sole proprietorship na kung saan yung personality ng isang sole proprietorship is yung personality ng kanyang sole proprietor. So yan, a partnership has a separate juridical personality from its partner, and with that, it has its own rights and obligations. Now, ito principles of delectus personarum. Additional note lang to, pero it's an important principle with the contract of partnership. Delectus personae, the selection or choice of the person, meaning you have the liberality to choose. Now, anong implications ito? The assignment of a partner of his shares does not make assignee a partner. Bakit? Kasi as we know, itong si assignee, si partner lang ang pumili. Yung isang partner lang ang pumili without the consent of the other partners. So, because of that, hindi mo pwedeng matrato itong si assignee as a partner kasi yung pagiging partner is a choice by the person, and hindi si assignee yung pinili nilang maging partner, but rather the assignor, the other partner. And the existence of the partnership is closely tied up to the particular contractual relationship of the partners. So, gaya na sabi dito, selection or choice, pinili mong makipag-partner sa specific na tao na yan. Yung naging particular contractual relationship nyo. Now, doctrine of delectus personae. The birth and life of a partnership at will is predicated on the mutual desire and consent of the partner. The right to choose with whom a person wishes to associate himself is the very foundation and essence of that partnership. Kasi, kayo mismo ang nagpilian sa isa't isa na magiging partner kayo. Walang ibang pwedeng pumasok dyan. Kayo lang. Yan si doctrine of delectus personae. The liberality of the partners to choose each other to become a partnership or to form a partnership. Now, anong meaning ng mutual agency? Ito yung mga excerpts provided by the law. In the absence of a contractual stipulation, all partners shall be considered agents, and whatever any of them may do alone shall bind the partnership. Partners can dispose the property, admission, evidence against partnership, notice to any partner, wrongful, blah blah blah, blah blah blah. So, Anong meaning nito overall? Kasi provided to ng batas eh. Meaning lang ng mutual agency, the action, generally, the actions, in the absence of, generally, the actions of one partner pertains to the will of the other partners. Meaning, kung anong ginawa ng isang partner, it is presumed na yun din yung gustong gawin ng ibang partners. Because partners are generally considered as agents of the partnership. Generally yan. Now, pag may mga exceptions yan, like, paano pag limited partner lang siya, paano pag silent partner, walang gagawin. So, hindi siya magiging agent, pero generally, the partners are agents of the partnership, and because they're agents of the partnership, their acts will represent the will of other partners. Yan si mutual agency. Now, unlimited liability. So, all partners are liable pro rata with all their properties and after partnership assets have been exhausted for all partnership debts. So, as we know, sa contract of partnership, ito, meaning lang nitong lahat ng to, kasi excerpts na to ng batas eh. Ano din? Kalimutan ko sabihin ko. Kasi excerpts na to ng batas eh. And as provided by the law, kapag na-exhaust na yung properties ng partnership, pwedeng habulin yung separate partners. As opposed kay corporation na up to the point lang or up to the point lang ng ownership ng shareholders. Yun lang yung kanilang liability, kaya tawag nga doon limited liability, di ba? Now, any stipulations against personal liability of partner from partnership debt is void except as among them. Now, as we know, kahit limited partner man yan, kahit industrial partner man yan, they are still liable for the partnership debts to third persons. Hindi pwedeng ilagay sa partnership na itong si industrial partner, hindi to sa liable sa debt for the third persons. Hindi, void yun. Kasi lahat sila liable. Now, paano yan? Well, among themselves, they can contract na the industrial partner is still liable, pero i-compensate na lang siya ng mga ibang partners for his payment of that liability. Kaya nga nakalagay dito, except as among themselves. Kung saan, except as among themselves na, in the eyes of the third persons, liable lahat ng partner. In the eyes of the partner, i-compensate na lang nila yung isang industrial partner na hindi magiging liable. So, yun yung meaning ng Article 1817. All partners are liable solidarily with the partnership for everything chargeable to the partnership when caused by the wrongful act or omission of any partner acting in the ordinary course of business or with authority from the other partners and for partners act of misapplication of property. So as we can see here, kapag yung agent or the partner itself acts within the ordinary course of business or with the authority of the other partners, tapos yung act na yun is unlawful, the whole partnership or the partners are solidarily liable. Na kapag hindi yan ordinary course of business or kapag hindi yan or wala yung authority ng ibang partners, itong partner lang na nag-commit ng wrongful act or omission ang maging liable kapag hindi ordinary course of business or kapag walang authority from the other partners. Kasi bakit mo naman sila bibigyan or bakit mo naman sila gagawing liable, wala naman silang kasalanan at hindi naman yun under the ordinary course of business. Now, a newly admitted partner into an existing partnership is liable for all the obligations of the partnership arising before his admission but out of partnership property shares. Now, as you can see here, kahit na new partner, let's say yung partnership nag-exist na for how many times, then ito, may bagong partner na pumasok. No, that bagong partner na pumasok, he is still liable for the he will be liable for the he will still be liable for the present and past obligations of the partnership kahit na bagong pasok lang siya, but out of the partnership property shares. Now, partnership creditors are preferred to those each of the partners as regard the partnership property. So, kapag nagkaroon ng liquidation, ng partnership, yung mga properties ng partnership, ang priority bibigyan is yung mga creditor to satisfy the liability to those creditors. Last na tong mga partners na bibigyan ng shares from that liquidation. And lastly, upon dissolution of the partnership, the partners shall contribute the amounts necessary to satisfy the partnership liability. Ito na, kapag nagkulang yung partnership property to satisfy those liabilities, magiging unlimited liability yan kasi kailangan na nilang mag-contribute ng kanilang personal shares to satisfy those liabilities. So yan si unlimited liability. Now, additional notes in distinguished from co-ownership incorporation, si creation daw ni partnership created by contract by mere agreement of the parties, si co-ownership created by law, corporations created by law. Now ito medyo not necessarily pero kasi as we know, the contract of partnership is provided by the law na kung saan ang partners enter into a contract of partnership. That provision, that action is provided by the law. So, medyo yung creation niya, mas believe ako na it is created by law and perfected lang by the creation of a contract or the mere agreements of party. Pero itong sabi ng reviewer, so hayaan na natin. Wala namang mali. Juridical personality, meron. Ito wala. Ito meron. Purpose, realization of profit, common enjoyment of thing or right, depends on the IOI kasi merong mga profit corporation, merong mga non-profit, yung mga foundations. So, nakadepende sa ano nakalagay sa articles of incorporation, duration, term, or existence. Generally, walang limitations kasi pwede silang mag-operate hanggang kailan nila gusto. 10 years maximum. Ito naman, 50 years maximum. Then, 50 years instance. Ito yata nabago na sa hindi ako sure pero parang nabago to sa bagong revision ng corporation code. Check ko na lang later. Disposal, transfer liability to partnership. Sa partnership, hindi niya pwedeng i-dispose yung kanyang interest unless agreed upon by all the partners. Ito pwede, ito pwede. Without prior consent. Powers to act, effect of death, dissolution. So mga additional notes na lang to. Pumunta tayo sa additional notes rin to. A particular partnership is distinguished from a joint venture. Paano? Well, a joint venture daw, which is an American concept, similar to a joint account, is a sort of informal partnership with no firm name and no legal personality. So basically, in a joint account, the participating merchants can transact business under their own name and can be individually liable. And lastly, and second, usually but not necessarily, a joint venture is limited to a single transaction. Although the business of pursuing to a successful termination may continue for a number of years, a partnership generally relates to a continuing business of various transactions of a certain kind. So, ano meaning nito? Pagkahaba-haba. Ang meaning lang yan, ito may dalawang entity na gustong pumasok sa isang business transaction. So, gano'n. Pero, they still retain their separate personality. So, with that, it is called a joint venture. Two separate personalities, two separate entities, nag-decide na pumasok sa isang business transaction. Or a joint venture. Like, for example, itatayo yung Bataan Airport, mga firm magsama-sama para sa transaction na yun, or magtatayo ng roads, magtatayo ng mall, or papasok sa isang sales contract na kung saan sila yung mga sellers o buyers. So, just for a particular business transaction lang. Pero, it would seem that under the Philippine law, a joint venture is a form of partnership, specifically a particular partnership which has for effects an objective which is for specific undertaking. So, under the Philippine law, itong joint venture na to, pwede mong i-consider na a form of partnership under particular partnership. Bakit? Kasi same yung object nila, same yung purpose. Specific undertaking. For a particular business transaction lang sila magsasama. Now, ano mang weakness or kahinaan ng isang partnership? Well, ito. Partners are co-owners of the partnership
properties and enjoy personal possession. Bakit to kahinaan? Well, may kahati ka. Hindi sa'yo napupunta lahat ng interest. Partnership eh. Second is partners may individually dispose of real property of the partnership even when in partnership name. Now, for example, under the ordinary course of business, because he's an agent of a partner, of the partnership, bigla na niyang binenta yung isang property na hindi mo pwedeng kontahin kasi karapatan niya yun eh. Kasi baka ginawa niya yun ordinary course of business, so it cannot be considered a wrongful act kasi nga agent of the partnership siya, pwede niya yung gawin. Basically, minimin lang nito is may kahati ka sa operations and decision making ng partnership. Hindi lahat nakasalalay sa'yo. Third is that dissolution of the partnership can come about by the change in the relationship of the partners, such as when a partner chooses to cease being part of the partnership. Now, ito, kahinaan to kasi pwedeng basta-basta na lang ma-dissolve yung partnership. Like for example, one day naisip na isang partner ay ayaw ko na makipag-partner. Or basically, yung isang partner namatay. Automatic, madi-dissolve yung partnership, madi-dissolve yan. Or naging incapacitated ang isang partner bigla-bigla. So because of those circumstances provided, yung partnership, madali yan siyang ma-dissolve, madaling mag-end. Expulsion of the partner, ito, expulsion, pag tinanggal, inalis sa partnership, itong partner, dissolve agad. Dissolve by the loss of thing promised to be contributed to partnership. O, nag-start kayo. Sasabi mo, itong kotse ko, i-contribute ko. Now, kapag nawala yung kotse na yan, nakarnap. Since yan yung promise contribution mo, hindi mo natupad yung promise mo. So, madi-dissolve yung partnership. Death, insolvency, or civil interdiction of a partner dissolves the partnership. Kasi, incapacitated na eh. Incapacitated na. Tapos ito, namatay pa. Paano magiging partner yan? Nawalan siya ng karapatan. Nawalan siya ng rights and duties. Basically, nawalan siya ng capacity to act on his own, to enter into contracts, to enjoy his rights and perform his duties. So kapag ano nangyari, paano magiging partner yan? Hindi niya ma-perform yung obligations ng partnership. Ito pa. Petition by partner will dissolve the partnership when a partner has been declared insane or the partner has become incapable of performing his part of the partnership contract. A partner has been found guilty of such conduct as tends to affect prejudicially the partnership business. Partner will willfully or persistently commit a breach of partnership agreement. The partnership business can only be carried at loss other equitable reasons. Ito, basically sinabi lang kung ano mga other circumstances na pwedeng maging cause ng pag-dissolve ng isang partnership. Like petition to dissolve, naging insane, naging incapable, and others. Ito, nakalista. Now, take note, additional note rin. Sabi ng Securities and Exchange Commission of April 28, 1995, the death of a partner, as a general rule, dissolves the partnership. Kaya sabi ko dito, generally. Kasi, except if the articles of partnership stipulate for the continuance of the partnership relations upon the death of any of the partners. So, sabi daw ni SEC, generally, kapag namatay yung partner, dissolve ang partnership. Exception, kapag sa stipulation ng partnership articles or sa articles of partnership, sinabi dyan na, kahit mamatay ang isang partner, continue pa rin ang business. Pwede daw, sabi ni SEC. Pwede pang mag-operate. Bakit? Kasi yung namatay na partner, nag-agree siya dyan. Nag-agree siya sa stipulation na yan na pwede pang mag-continue ang partnership kahit namatay siya. So, since there's an agreement among the partners on that particular it is the will of those partners to continue the business even though one of them has died. So, okay lang daw, sabi ni SEC sa kanyang opinion. Another opinion on August 5, 1997, if the remaining partners of the dissolved partnership intended for all legal intents and purposes to continue the partnership business even after the death of a partner, there is continuity of personality of the partnership as there exists a partnership at will. It is their own will to continue the business. Ito, kinds of partnership na yan. Now, rules to determine existence of partnership. So, paano natin malalaman na isa yung bagay na yan, isang partnership? Ano ang mga rules? Well, general rule, persons who are not partners as between themselves cannot be partners as to third persons. Meaning, kung hindi ka partner, kung hindi kayo mag-partner, hindi mo pwedeng ipakita sa mga third persons na mag-partners kayo. Exception, partnership by Estoppel. Ito yung you're showing to the third persons, yung pinapakita mo, dinidisplay mo na mag-partners kayo. Kaya, tawag sa kanya partnership by Estoppel. Mamaya yan sa kinds of partnership. Other rules to determine whether a partnership exists. Co-ownership or co-possession does not itself establish a partnership. Tandaan nyo yan, kasi itong partnership, kailangan may contract. Pero minsan, oral lang, okay na. So, tandaan nyo, kasi iba talaga ang co-ownership sa co-possession. Now, the sharing of gross returns does not of itself establish a partnership, whether or not the person sharing themselves by joining common right or interest in any property from which the returns are derived. Like for example, renta sa lupa. Magkapatid kayo. Pareho kayong may shares sa lupa na yan. Tapos may pinaparenta dyan. Kung pinaparenta dyan, may bayad na renta sa inyo. Now, from that alone, hindi nyo pwedeng sabihin na mag-partners kayo. Ang pwede nyo lang sabihin is co-owners kayo. Kasi, at the first place, walang intent, walang consent from the both of you na maging partners. So, co-ownership lang ang trato sa inyo. Another is the receipt by a person of a share of the profits of a business is prima facie evidence that he is a partner in the business, unless such were received in payment. Ito. So, meaning daw, ito naman, for this particular instances, mayroong business. Ngayon, ang business nagbigay ng pera. So, prima facie, you will be considered as a partner. Mako-consider mo siyang as partner. Kasi, receipt of a person of the share of the profit of a business. Ibig sabihin, may business, itong tao nakatanggap ng profit from that business, prima facie, or it is an assumption na yung partner na yun is, yung tao na yun is a partner to that business. Yun yung general rule. Kaso, itong exception. Kapag yung payment na yun was received as debt by installment, as wages or rent, annuity, interest or loan, or consideration for sale of goodwill, of business by or other property by installment, well, hindi mo matatratong partner yung taong yun. Kasi ito, hindi naman to ni-receive for profit. Ni-receive to para magbayad ng utang or other obligations. Now, let's say, unlawful yung partnership. Kasi may mga requirements na hindi na satisfy. So, ano magiging effect ng isang unlawful partnership? Well, first, the contract is void ab initio, void from the very beginning. And the partnership never existed in the eyes of the law. So, wala talaga siyang existence right at the first place. Now, the profits shall be confiscated in favor of the government. Bibigay yan sa government. The instruments or tools and proceeds of the crime shall also be forfeited in favor of the government. Ito, kasi alam natin, pag unlawful, may nilabag kang batas. Illegal yan. So, kapag illegal yan, usually kinukuha yan ng government. Yung mga properties and profits from that, isa-sequester yan ng government. Fourth is that the contribution of partners shall not be confiscated unless they are under number 3, Articles 1411 and 1412. So, usually ito yung mga illegal yan. Like for example, if tama pagkakalala ko, basta mga illegal items. Kapag hindi naman illegal items, pwede nila yung mabawi. Now, judicial decree is not necessary to dissolve an unlawful partnership. Hindi na kailangan ng desisyon ng korte para hindi na kailangan ng desisyon ng korte para sabihin pang i-dissolve yung partnership na yan. Automatic, basta may nilabag sa batas, basta unlawful siya, automatic dissolve yan. Now, anong effects ng partial illegality? Meaning, a part of the partnership is legal while the other part is illegal. Well, when a part of a business or partnership is legal and a part illegal, an account of that which is legal may be had, where without the knowledge or participation of the partners, the firm's profits in a lawful business has been increased by wrongful acts. The innocent partners are not precluded as against the guilty partners from recovering their share of profits. No? Kapag partial legal and partial illegal, tapos yung profits, tapos yung partnership may profits, yung mga innocent partners na hindi nag-participate sa illegal undertaking, pwede nilang ma-recover yung kanilang shares of profits. Na take note, yung share of profits na yun, yung mga nanggaling lang sa legal, hindi pwedeng nanggaling sa illegal. Tandaan nyo yan. Now, sino-sino yung pwedeng mag-enter sa isang partnership contract? Sino-sino pwedeng maging partner? Well, sabi ng batas, any person capacitated to contract may enter into a contract of partnership. So, basta daw, pwede kang pumasok sa isang contract, pwede kang pumasok sa isang contract of partnership. Yun yung general rule. And pag may general rule, may exceptions. Anong first exception? Persons who are prohibited from giving each other any donation or advantage cannot enter into a universal partnership. Now, usually, itong mga persons prevented from giving donations to each other, ito yung mag-asawa, ito yung kabit ng asawa, yung asawa ay yung kabit niya, yan, mga taong yan, bawal silang magbigay ng donations from each other. Mga mag-asawa, yung mga kabit, ay yung asawa, bawal yan. So, hindi sila pwedeng makagawa ng universal partnership. Second, person suffering from civil interdiction. Now, so you know, civil interdiction, ito yung klase ng tao na tinanggalan ng karapatan to manage his properties. Tinanggalan siya ng karapatan on certain aspects ng kanyang buhay. Gaya na sabi ko, such as managing his properties. Na kung hindi mo manage yung properties mo, anong makakontribute mo sa partnership? Ano ang magagawa mo sa isang partnership? Nawalan ka ng karapatan mag-manage. Third is persons who cannot give consent to a contract. Well, as we know, a contract of partnership is perfected by mere consent. Kailangan magbigay ng consent ang tao kasi yung consent na yan, that will show the intent of the person to enter the partnership at the first place. Now, if you cannot give consent, you cannot enter into a contract. Kaya ng minors, insane persons, deaf mutes who do not know how to write. Now, may corporations enter into a partnership. Well, ito, based on the opinions ng SEC, corporations may enter into partnership agreements on the following conditions. Authority to enter into a partnership relation is expressly conferred by the charter or the articles of incorporation, and the nature of the business venture, kita nyo, business venture, to be undertaken by the partnership is in line with the business authorized by the charter or articles of incorporation. So ito, business venture, particular undertaking, specific undertaking, pwede daw. Basta allowed ng charter or ng articles of incorporation ng corporation, and yung papasukan nilang business venture, yung papasukan nilang specific undertaking is in relation to the business authorized by the charter. Like for example, construction company yan. Papasok sa isang business venture. Na dapat yung business venture na yan involves constructing something. Constructing roads, constructing an airport, constructing a seaport. And dapat allowed yan sa kanyang charter or sa kanyang articles of incorporation. Second, if it is a foreign corporation, it must obtain a license to transact business in the country in accordance with the Corporation Code of the Philippines. So ito, SEC opinions lang to, kung saan yung partnership yung corporations pwedeng pumasok isang partnership. Now, another rule. Paano naman kapag immovables or real rights ang contributed? Ito, na-mention natin kanina. Nasama lang ulit. Now, failure to comply with the requirement of appearance in public instrument and sex registration will not affect the liability of the partnership and members thereof a third person. Exception: when immovable property or real rights are contributed, public instrument plus inventory of that property made and signed by the parties and attached to the public instrument is required for the benefit of third persons. Why? Because as we know, immovable properties are usually real properties which confers real rights. And as we know, real rights, it is a right against the entire world. Entire world is the right against the entire world. Kasi it is different from personal right, kasi yung personal right between the persons. Ito naman, itong real rights, you are conferring your right against the world, against other third persons. So because of that, kailangan naka-public instrument yan. Kasi pag naka-public instrument yan, pinapakita mo na pagmamay-ari mo yan, and you are doing something to it, to the third persons. Parang yan yung purpose ng public instrument. Now, effects of absence of requirements under Article 7071 and 7073. Ito, in connection with this. Paano daw pag wala yung mga requirements needed? Well, ito, first, kapag walang public instrument and kapag walang inventory of the property, sabi ng mga authors na to, void. Kapag mayroong public instrument pero walang inventory ng property, void pa rin. Now, ito, kapag walang public instrument pero may inventory ng property, ang sabi ni Bautista, valid but either party may compel execution of public instrument so it may be registered in the register of property. Nonetheless, partnership agreement may be enforced. Pero sabi ni De Leon, void yan. Walang kaya ang sabi ng batas, kailangan merong public instrument, kailangan merong inventory para maging valid. Sabi ni Bautista, okay lang yan. Basta makompel yung execution ng public instrument, i-compel mo. Pero kay De Leon, ayaw. Wala at the first place, so void yan. Ito, with public instrument and with inventory of the property, nag-agree sila. Valid. Sinasatisfy yung requirement eh. Now, pumunta naman tayo sa classification of partnerships. Ano-anong mga kinds of partnership meron? Well, first, as to extent of its subject matter. Una kay universal partnership kung saan may dalawang under sa kanya. Una si of all present property, second si partnership of profits. Now, kay all present property, it comprises of the following. Una si property which belong to each of the partner at the time of the constitution of the partnership, and second, profits which they may acquire from all property contributed. Kay universal partnership of profits naman, it comprises of all that the partners may acquire by their industry or work during the existence of the partnership. So as we can see, yung subject matter of all present property, which from the name itself, all the present property, yung mga property daw na pagmamayari ng mga partner at the time of the constitution, and yung profits na napoproduce ng mga properties na yon. Kay partnership of profits, yung sa kanya lang kung ano yung ma-acquire ng mga partners during the existence of the property. Now take note, persons who are prohibited from giving donations or advantage to each other cannot enter into a universal partnership. Ito yung nasabi natin kanina, yung mga mag-asawa, and yung asawa and yung kabit niya, bawal yan kasi bawal silang mag-donate sa isa't isa. Now, second subject matter is yung particular partnership. Kasi yung objects niya is for determinate things, their use or fruits, and specific undertaking. Ito, yung sa joint venture, yung business venture na na-discuss natin kanina. And lastly, exercise of profession or vocation. Na kapag ito yung objects na, kapag ito yung subject matter niya, particular partnership siya. And kung makikita natin, yung kay particular partnership, medyo or specific yung kanyang pinipertain na subject matter. Now, pumunta naman tayo sa second classification, which is the liability of partners. Now, una, si general partnership, ito alam natin to, consists of general partners who are liable, pro rata, and subsidiarily, and sometimes solidarily with their separate property for partnership debts. Lalo na kapag yung partnership property is not enough to satisfy those liabilities. So, si general partner, iso-shoulder niya yung liabilities na yun para masatisfy lang. Now, si limited partnership naman, one that is formed by two or more persons kung saan yung isa, kung saan yung members, one or more general partners, and one or more limited partners. The latter, itong semi-limited partner, not being personally liable for the obligations of the partnership, meaning his liability only extends up to his contribution to the partnership. Yung magiging personally liable si general partner na. Yan kay limited partnership. Now, as to duration naman, kung gaano katagal maglalas ang isang partnership. Una, si partnership at will, from the word itself, one each which no time is specified and is not formed for a particular undertaking or venture which may be terminated anytime by mutual agreement o at will. Meaning, as long as gusto pa ng partners na maging partners sa isa't isa, meron pa ring partnership na mateterminate lang ito kapag nag-decide na yung mga partners na ayaw na nila by mutual agreement na ayaw ko na. Di mag-end na ang or madi-dissolve na ang partnership. Now, pangalawa is yung partnership with a fixed term. The term of which the partnership is to exist is fixed or agreed upon or one form for a particular undertaking. So, kapag may agreement or kapag it was formed for a particular undertaking, it is a partnership with a fixed term. May ending, may stated ending ang kanyang buhay. Now, as to the legality naman of existence, meron tayong de jure at de facto. Ito, alam natin, familiar na tayo sa concept na to. Kasi de jure, one which was complied with all the legal requirements for its establishment. Meaning, it is a partnership in the eyes of the law. Si de facto naman, one which has failed to comply with all the legal requirements for its establishment, meaning it is not a partnership in the eyes of the law, pero nag-ooperate pa rin siya as if that partnership is a legal partnership, is a lawful partnership, kumbaga. Kahit na in the eyes of the law, hindi talaga siya legal partnership kasi or lawful partnership kasi he was not able to comply with the requirements needed. Next classification is as to purpose. Ano ba yung purpose? Bakit pinorm yung partnership na yan? Una is it commercial or trading, kung saan it was formed for transaction of business. Pangalawa is for professional or non-trading, kung saan it was formed for the exercise of a profession, gaya ng mga auditing firm, mga law firm, architectural firm, engineering firm, in the exercise of their profession. Now, anong mga klase ng partners meron? Well, marami sila. Una, si capitalist, yung nag-contribute ng pera or property sa common fund. Si industrial na, ang kinontribute niya is industry or personal services, yung expertise niya, connections, yun yung naging contribution niya. Ito naman si general, ito yung may liability sa third person extends to his separate property. As opposed kay limited, na kung saan yung liability niya lang is up to the extent of his capital contribution, kung ano lang yung kinontribute niya. Now, si managing, one who manages the affairs of or business of the partnership. Si liquidating, siya yung magti-take charge of the winding up of partnership affairs kapag ito ay na-dissolve na. And next, si partnership by Estoppel, kung saan hindi talaga sa partner at the first place, but he will be liable as a partner. Bakit? For the protection of innocent third persons. Kasi as we know, itong si partners by Estoppel, ito yung ni-represent niya ang sarili niya as if he is a partner of a partnership, even though in reality, he is not. So because he represent himself as a partner of a partnership, tapos naniwala yung third persons na partner siya, tapos nagkaroon ng loss or damages for that third person, then that partner by Estoppel will be liable to that third person because he falsely represented himself as a partner of a partnership, which in reality, wala naman talaga. Next is continuing partner, kung saan one who continues the business of a partnership after it has been dissolved by reason of the admission of a new partner, retirement, death, or expulsion of a new partner. So meaning, parang continuation lang siya or from the word itself, continuation, na kung saan na-dissolve na pero nag-continue pa rin ang business transactions. Next is the surviving partner. Ito yung one who remains after a partnership has been dissolved by death of any of the partner. Siya lang yun natira. Sub-partner, one who is not a member of the partnership who contracts with the partner with reference to the latter's share in the partnership. Ito, matidiscuss to yung as to the interest of one of the partners, nagkaroon sila ng separate transactions na kung saan itong si sub-partner, kahit hindi sa part ng partnership, mayroon siyang interest sa interest ng actual partner to that partnership. Ostensible, one who takes an active part and known to the public as a partner in the business. Meaning, alam ng public na partner siya sa business and he is actively managing the partnership, or the business. Si secret naman, he takes active part pero hindi siya kilala ng public, kilala lang siya ng mga partners. Kaya nga secret eh. Next is silent. Ito naman si silent, si secret, hindi siya kilala pero nagtitake siya ng active part sa pag-manage ng business. Si silent naman, wala talaga siyang ginagawa. Hindi siya nagtitake ng active part in the operations of the business, pero pwede siyang makilala ng mga third persons na partner siya sa isang partnership. Lastly, si dormant, kung saan hindi na nga siya nagtitake ng active part sa partnership, hindi pa siya kilala bilang partner ng partnership. So, pumunta naman tayo sa chapter 2, kung saan ito yung obligations of partners. Ano-ano ba ang mga obligations na meron ang partners sa partnership? Una, let's discuss obligation of the partners to one another. Ano bang mga obligations nila sa isa't isa? Una, promise contribution. Siyempre, magtatayo kayo ng partnership eh. Mag-i-start kayo. Kailangan may contribution ka to the common fund. Now, obligation with respect to contribution of property. To contribute at the beginning of a partnership or at the stipulated time, the money, property, or industry which he may have promised to contribute. So, pag-usapan nila saan i-contribute, anong oras i-contribute yung kanilang money, property, or industry to the common fund. Next is to answer for eviction in case the partnership is deprived of the determinate property contributed. Meaning, kapag hindi na-satisfy ng isang partner yung kanyang contribution, baka may defect, na delay, he will answer to that. Magiging liable siya for that. Kasi pre-promise niya na ito ang i-contribute niya. So, since he made that promise, kailangan, kung anong pre-promise niya, yun yung tinupad niya. Dapat walang defect, dapat maayos yung conditions, dapat kung kailan kailangan, doon niya kinontribute. So, he will answer to those liabilities kapag hindi niya na-satisfy yung requirement. C, to answer to the partnership for the fruits of the property, the contribution for which he delayed from the date they should have been contributed up to the time of the actual delivery. So, may stipulated time na, may pinag-usapan na silang panahon, date, oras kung kailan i-contribute yung property. Kaso itong isang partner na delay. So, kapag na-delay siya, he will not only be liable for the property itself, but also to the fruits of the property, including the interest. Kasi nagkaroon ng delay. As you know, pag nagkaroon ng delay, may mga kailangang additional damages kailangan bayaran. Gaya ng mga fruits, kailangan kasama yan, interest, etc. D is to preserve said property with the diligence of a good father of a family pending delivery to partnership. Siyempre, habang hindi mo pwede i-deliver, kailangan mong ingatan yung promise contribution mo. Kasi, you are obliged or you are compelled to deliver what you have promised to contribute. Dapat walang defect yan. Dapat nasa maayos na condition. Lastly is to indemnify partnership for any damage caused to it by the retention of the same or by the delay in its contribution. So, ganyan tayo, liable for any wrongdoings. Oh, let's say, nagkaroon ng failure to contribute sa property na prinamis ng isang partner. Ano ang magiging effect nito? Well, dito binigyan tayo. Partners become ex-jure, a debtor of the partnership, even in the absence of a demand. So, hindi na kailangan mag-demand ng partnership para i-compel pa para sabihan pa si partner na hindi nag-contribute ng maayos. Automatic, magiging debtor na siya. And since is a debtor, kailangan niyang i-satisfy yung obligation na yun. Kailangan niyang ma-deliver yung property promise. Next is si remedy. Remedy of the other partner is not a rescission. Siyempre, huwag mo na rescission. Huwag mo na nilang i-end yung partnership. But rather, specific performance na lang na may kasamang damages sa defaulting partner. Now, obligations with respect to contribution of money and money converted to personal use. So, ano magiging contributions? Ano magiging obligations ng isang partner na kung saan required siyang mag-contribute ng pera, and kapag humiram siya ng pera from the partnership para gamitin niya for his personal use? Well, first, he's obliged to contribute the money kung kailan nila pinag-usapan. Second, kapag humiram siya ng pera sa partnership kung saan gagamitin niya for his personal use, siyempre, required siyang ibalik yun. Required siyang mag-reimburse. Now, kapag naman mag-reimburse nga siya, pero na-delay siya kung kailan niya i-reimburse, well, he will be, or papatungan siya ng penalty, such as legal interest because of that delay. As we know, kasi delay nga na-delay siya sa pagbayad, so may interest na kasama yan, which is considered to be a penalty. And second, kapag nag-cause ng damage yung delay niya sa pag-contribute or pag-remit ng pera ng partnership to the partnership, he will be liable for that damage because of the delay on his part. So yan ang obligations with respect to contribution of money and money converted for personal use nang hiram siya ng pera sa partnership. Now, fiduciary duty. This is another obligation of the partners among themselves. So ano ba tong fiduciary relation between the partners? Well, ito yung one entered into and to be maintained on the basis of trust and confidence. On the basis of trust and confidence. Meaning, may tiwala ang partner sa isa't isa. May confidence sila sa isa't isa. Yun yung naging basis kung bakit sila, at the first place, pumasok sa isang partnership. Now, with that, a partner must observe the utmost good faith, fairness, and integrity in his dealings with the others. Siyempre, nagtiwala kayo. May confidence kayo sa isa't isa. Huwag mong sirain yung tiwalang yun. So, ano naman kailangan niyang gawin? Ano yung mga hindi niya dapat gawin para hindi masila yung tiwalang yun? Well, he cannot directly or indirectly use partnership assets for his own benefits. Kasi, kaya nandyan yung partnership assets para makapag-operate yung partnership, para makapag-produce ng profits to be distributed among the partners. Second, he cannot carry on a business of the partnership for his private advantage. Siyempre, for common advantage yan ng mga partners. Third, he cannot, in conducting the business of partnership, take any profit clandestinely. Fourth is that he cannot obtain for himself that he should have obtained for the partnership. Meaning, kapag may opportunity ang partnership, kapag mayroong possible opportunity, let's say, may gustong bumili ng bahay, tapos yung partnership nyo, nagbebenta ng properties. Tapos ikaw, mayroon kang kilala na pwedeng magbenta ng bahay, tapos nakita mo, may gustong bumili ng bahay na instead na i-refer mo yung partnership mo, pumunta ka doon sa kabilang party kung saan mas magbe-benefit ka doon. Na kapag ganun nangyari, bawal yun. Kasi tinanggalan mo ng opportunity kumita ang partnership kung saan partner ka. Parang niloko mo yung partnership mo. Mas prioritize mo yung sarili mong pangangailangan kaysa sa pangangailangan ng partnership. Naging gahaman ka, naging greedy ka, kumbaga. And he cannot carry on another business in competition with the partnership. Let's say, ang partnership nyo is producing pancit canton. Tapos ikaw, since may sarili kang kapital, since mayaman ka, nagpatayo ka ng sole proprietorship na kung saan nagproduce rin ng pancit canton. Ipso facto, automatic naging competition ka with your own partnership kung saan partner ka. Loko ka naman. Ginago mo yung partnership mo. Hindi mo yun pwedeng gawin. F is that he cannot avail himself of knowledge or information which may be properly regarded as the property of the partnership. Meaning, like for example, may intellectual property ang partnership na kung saan ginagamit ito sa kanyang business. Hindi mo pwedeng basta-basta gamitin yon for your own personal use kasi it will infringe upon the right of the partnership. Kasi yung partnership na yun ang gumagamit ng intellectual property na yun. So, sample lang yun. Now, let's say may mga business ang mga partnership na hindi lang involved sa partnership yung isang partner. Pwede rin siyang pumasok sa ibang business. So, ano mga prohibitions na meron tayo? Well, kapag yung partner is an industrial partner, well, he cannot engage in business, lalo na kapag, he cannot engage in business within same line of business with the partnership unless partnership expressly permits him to do so. So, kapag industrial ka, siyempre ang kino-contribute mo, industry. Now, kapag may opportunity kang pumasok sa isang or gumawa rin ng additional business kung saan same kayo or in the same line with the same business of a partnership, hindi mo pwedeng gawin yon unless may express permission from the other partners to do so. Pero kapag yung business na pwede mong pasukan is not in line with the business of a partnership, pwede lang. Now, si capitalist partner naman, he cannot engage in business with the same kind of business partnership for his own account unless there is a stipulation to the contrary. So, now, mali yata na sulat ko dito. Dito kasi si industrial partner, if tama ang pagkakaalala ko, basta kahit anong business man yan, inline ba yan, same kind ba yan sa business ng partnership or different, he cannot engage in any other business. Bakit? Because he's an industrial partner. His main contribution is his industry himself. So, hindi siya pwedeng magpunta sa ibang business, inline man yan or not, of the same kind with the partnership. Pagdating kay capitalist partner, he can, as long as he is allowed, he can with the same kind of business. Na paano naman pag hindi same kind, other kinds of business, pwede siyang mag-engage even without the express stipulation or consent of the partners. So, swerte si capitalist. So, ulitin natin, si industrial partner, kahit anong klaseng business man yan, hindi siya pwedeng mag-engage. Kasi dapat yung focus niya lang is with the partnership. Kasi, he's an industrial partner. Ang contribution niya, industry niya, service niya. So, hindi siya pwedeng mag-engage kasi mawawala siya ng focus sa partnership. Pagdating naman kay capitalist partnership, una, kapag same kind of business, hindi siya pwedeng mag-engage on others unless may stipulation on the contrary. Ibig sabihin, he's permitted to do so. No, kapag other kind of business yan, other line of business, pwede siyang mag-engage kahit walang permiso ng mga partners. So, tandaan yan. Now, consequence, if an industrial partner engages in any business. So, ito na. Kasi ito mali ang wording dito. Hindi talaga siya pwedeng mag-engage. Dapat yung sole attention niya nasa partnership. Na ano mangyayari kapag si industrial partner nag-engage, matigas ang ulo, nag-engage sa other business? Well, first, he can be excluded from the partnership. Pwede siyang alisin. Second, the capitalist partners can avail of the benefit he obtained from the business. Kung anong kinita ni industrial partner, pwedeng kunin niya ni capitalist partner. Third is that the capitalist partner have the right to file an action for damages against the industrial partner. In either case, ito sa dalawa. Kasi there's a betrayal of trust eh. Dapat si industrial partner nakafocus lang ng kanyang services sa partnership pero pumunta sa iba, kumaliwa. Niloko ang partnership. Dapat ang focus niya nasa partnership lang pero pumunta sa iba. So because of that violation, because of that wrongful act, well, liable si industrial partner. Now, ano naman ang mangyayari kapag itong si capitalist partner nag-engage sa business? And yung business na in-engage niya is a competition of the business of a partnership. Na kapag ganun nangyari, well, taking into account, i-assume na dito na walang permiso, he may be required to bring to the common fund the profits derived from the other business. So meaning, yung kinita niya sa other business, kailangan niyang ibalik sa kailangan niyang i-contribute sa common fund ng partnership. Second, he shall personally bear the losses on that other business. And third, he may be ousted from the partnership, especially kapag at the first place, ni-warningan na siya. Now, ano naman ang obligations ng mga partners with respect to contribution to partnership capital, yung contribution nila sa common fund? Now, partners must contribute equal shares to the capital of the partnership, generally, ang exception, unless there's stipulation to the contrary. So, generally, dapat yung contribution sila equal. Unless, yung stipulations nila, pwedeng hindi equal. B is that partners, yung mga capitalists, must contribute additional capital in case of imminent loss to the business of the partnership and there is no stipulation otherwise. Meaning, namumblema ang partnership. Kulang sila, like say, kulang sila sa cash to meet the payment of the liability and that will endanger the partnership. So, because of that, yung capitalist partner, yung nagko-contribute ng capital, he is obliged, he is now compelled to contribute additional capital to the partnership para hindi maapektuhan yung business ng partnership. And that will happen if there's no stipulation otherwise. No, paano naman kapag itong si capitalist partner ayaw niyang mag-contribute? Well, refusal to do so shall create an obligation on his part to sell his interest to the other partners. So, kung ayaw ni capitalist partner na mag-contribute mang additional capital, well, he will be forced to sell his interest of the partnership to the other partners kasi ayaw maging sportsmanship, ayaw makipagsama ni capitalist partner na, and it shows his utter disregard to the well-being of the partnership. So kapag ganun, ibig sabihin wala nang pake si capitalist partner, sa well-being ng partnership. Kapag ganun, well, might as well tanggalin na lang sa partnership. He will be forced to sell his interest to the other partners. Now, anong mga requisites nito? Well, there's an imminent loss to the business of the partnership. Majority of the capitalist partnership are of the opinion that additional contribution to the common fund would shape the business. Ibig sabihin, yung majority ng mga capitalist partners nag-agree, kailangan nilang mag-additional contribution para iligtas yung business. Kaso, letter C, merong isang capitalist partner na ayaw mag-contribute. Kung saan, not due to financial capability, meaning he's capable to contribute or to provide additional contribution. Kaso ayaw niya, nagmatigas. And the last agreement is, there's no agreement to the contrary. So kapag ito nag-check, yun, pwedeng mapuwersa, pwedeng makumpel yung matigas na ulo na capital partner na ibenta yung interest niya sa partnership to the other partners. Now, obligation of managing partners who collect debt from the person who also owed the partnership. Meaning, may isang tao na kung saan may utang siya sa partnership, may utang siya kay managing partner. Pareho siyang may utang sa dalawa.
Now, being the managing partner, siya yung liable or siya yung obliged na mag-collect ng payments ng utang sa partnership. Na kapag gano'n nangyari, paano niya i-appropriate yung binayad na utang? Sino ang ipaprioritize niya? Well, binigyan tayo ng options ng batas. Una, apply sum collected to 2 credits in proportion to their amount. Meaning, kapag yung binigay na pera sa kanya na pambayad ng utang is in his capacity as a not being the managing partner but rather a separate creditor of this person, ang gagawin niya, apply sum collected to 2 credits in proportion to their amount. Yan yung first scenario. On the second scenario, kapag he received the payment for the account of the partnership, meaning being the managing partner in the account of the partnership, the whole sum shall be applied to partnership credit. Lahat ng na-receive, the entire amount, yung partnership credit ang makikinabang. So dito, ang nangyari dito, he received the payment not being the managing partner, but rather as a separate creditor of this person. What the managing partner will do is to divide the amount received into proportions in accordance to their amount. Para may ma-receive si partnership, may ma-receive din siya. Pagdating naman dito sa second scenario, he received the amount for the account of the partnership, being its managing partner. Kapag ganun nangyari, the entire amount shall be credited to the partnership. Now, anong mga requisites? There exists at least 2 debts, one where the collecting partner is creditor and the other where the partnership is creditor. Both debts are demandable and the partner who collects is authorized to manage and actually manage the partnership, meaning sa isang managing partner. Now, paano naman kapag yung isang partner tumanggap ng share niya sa partnership credit? Obliged to bring the partnership capital what he has received even though he may have given receipt for his share only. Anong mga requisites? A partner has received in whole or in part his share of the partnership credit and the other partners have not collected their shares. The partnership debtor becomes insolvent. So meaning, kapag itong isang partner, let's say, dito, wala naman sinabing managing partner siya, so, ibig sabihin, ordinary partner lang siya. Tapos may natanggap siyang credit, may natanggap siyang bayad sa utang, na kung saan, separate creditor din siya, and separate creditor din yung partnership. Joke. No, mali tayo dito. Obliged to bring to the partnership capital what is has received, even though he may have given receipt for his share only. Ibig sabihin, may utang yung isang tao sa isang partnership, and being a partner in the partnership, tinanggap niya yung utang niya yun. Now, being a partner of the partnership, hindi niya pwedeng isolo yung amount na yun. Kailangan niyang i-contribute to the other partners. Kahit na, nung tinanggap niya yung pera na yun, he has only given the receipt for his share only. Kahit tinanggap niya yung pera na yun, na para lang sa share niya, kailangan niyang ihati yung amount na na-receive niya to the other partners that have not collected their shares. So, yun si obligation of partner who receives share of partnership credit. Now, bearing the risk of loss of things contributed. So, kapag yung property o yung bagay na kailangan i-contribute na wala, sino yung magbe-bear ng loss? Well, kapag specific and determinate thing which are not fungible, ang fungible, consumable yan. where only the use is contributed, meaning yung bagay na yung bagay na i-contribute mo sa partnership, gagamitin lang yun for its use. Ikaw, hindi nga fungible hindi siya i-consume. Yung risk ng pagkawala nun, borne by the partner. Dito naman, kapag yung specific and determinate things, the partners thinks the ownership of which is transferred, meaning, hindi lang yung use
ang ibibigay mo, but the ownership of the property itself, of the thing itself, when the risk is borne by the partnership. Dito, yung use lang yung ibibigay mo. Yung paggagamitan lang. Dito, yung ownership niya talaga. So, kapag ganun, si partnership na yung magbe-bear ng risk. Na paano naman pag fungible things or consumable? Well, the risk is borne by the partnership. Paano naman yung mga things contributed to be sold? Yung mga ibibenta, mga inventories ang kinontribute. The risk is borne by the partnership. Paano naman kapag yung kinontribute is brought and appraised in the inventory? Partnership rin ang magbe-bear ng risk pag nawala. And lastly, specific and determinate things which are not fungible where only the use is contributed. Na-copy-paste. Same lang. Risk is borne by partner na nag-contribute. Excuse me. Now, kaya nga nag-form ng partnership at the first place kasi gustong makapag-produce or makapag-gain ng profit ang partners from the operations. Now, nagkaroon na sila ng profit or kapag minalas, nagkaroon sila ng losses. Paano nila yun i-distribute sa isa't isa? Well, kapag may agreement sila, sundin nila yung agreement nila sa distribution ng profit or loss. No, kapag walang agreement, hindi nila pinag-usapan, kapag profits yan, share of capitalist partner is in proportion to his capital contribution. Kapag may industrial partner naman, share of industrial partner is not fixed, as may be just and equitable under the circumstances. Yan yung ma-receive niyang contribution or distribution from the profits. Na kapag naman losses, tas walang agreement, ano mangyayari? Well, if sharing of profits is stipulated, apply to sharing of loss. Sabi dito, kapag may agreement sa profits pero walang agreement sa loss, the loss will follow the sharing or distribution ng profits. Now, paano naman kapag walang profit sharing stipulated sa kanilang agreement? Well, the loss shall be borne according to their capital contribution. Kapag may industrial partner, that industrial partner will not be liable for losses. Kasi wala naman siyang kinontribute, industry niya. Alangan naman, magko-contribute siya ng pera sa partnership kapag nagkaroon siya ng losses. Hindi yun pwede. So, the industrial partner, purely industrial partner. Kasi meron tayong mga semi-capitalist, semi-industrialist. So, he will be liable for his semi-capitalist partner, being a partner. Pero pag for his semi-industrial partner, he shall not be liable. Dito, purely industrial, total, all in all, hindi siya magiging liable. Now, dito, additional note, according to Article 79 or 1799 of the New Civil Code of the Philippines, a stipulation which excludes one or more partners from any share in the partnership, in the profits and losses is void. Obviously, bakit? Kasi, as we know, the mere fact na kaya nag-form ng partnership yung mga partners is to earn profits that will be divided among themselves. Tapos sasabihin dito na i-exclude sila from the profits and losses. Well, parang katangahan yon. So, it is considered void. Pero take note, stipulation exempting a partner from losses should be allowed. Uy, bakit? Bakit ganun? Sabi dito kay 1799, void daw. Pero sabi dito, allowed. Well, take into consideration yung perspective na pinag-usapan. Yung perspective. Bakit? If a person can make a gift to another, there is no sound reason why a person cannot also agree to bear all the losses. Anong meaning yun? Meaning yun, parang wala lang. Kasi dito talaga yung pinapertain na concept. As far as the third persons are concerned, any such stipulation may be properly declared void. Dito na yung pinag-usapan nating perspective. Sa mata ng third persons, yung exempting ng partners from losses is void. Pero sa mata ng partners between themselves, yung exempting a partner from losses is allowed. So tandaan nyo, sa mata ng third persons,
yung exempting ng partner from the losses is void. Pero sa mata ng partners between themselves, sa perspective nila, yung exempting ng partner from losses is allowed. So, tandaan nyo yan. And yung sinite dyan yung Espiritu and Sibal. Now, obligation of partner. Now, let's say, management. Minamanage na yung partnership. So, anong mga rights and obligation with respect to management? Well, dito, binigyan tayo ng table. Partner is appointed manager in the articles of partnership. Meaning, sa article of the partnership, yung isang partner in-appoint. Siya yung magiging managing partner. Now, power of managing partner is irrevocable without just or lawful cause. It is only revocable kapag ginawa in bad faith. So, ito, as long as ginawa niya na maayos, as long as ginawa niya legally, kahit ayaw ng ibang partner, hindi pwedeng ma-revoke yung power niya. Marirevoke lang yung power niya kapag yung ginawa niya was in bad faith. Now, paano pag naging bad faith yung ginawa niya? Tapos i-revoke na yung kanyang power as a managing partner. Well, paano yun? Well, both of partners representing controlling interest necessary to revoke power, meaning kung sino may pinakamalaking capital contribution in total, in relation to the total capital contribution of partnership, kapag na-satisfy yun, he can revoke the power of the managing partner. Now, paano naman kapag yung partner is appointed as manager after the constitution of the partnership, meaning hindi nakalagay yung pangalan niya sa articles of partnership, yung power niya revocable at any time for any cause. Dito makikita natin, marirevoke lang kapag bad faith. Dito, it can be revoked anytime for any cause. Now, paano naman kapag yung managing ng partnership was entrusted to two or more person and without specification of duties or stipulation that each shall not act without the other's consent. Meaning, free for all. Basta na lang sinabi na itong dalawang to or two or more partners na to shall be managing partners. Anong mangyayari? Well, each of them may execute all acts of administration. Na, paano naman kapag nagkaroon ng disagreement between them? Well, in case of opposition, decision of majority shall prevail. Itong majority na pinag-usapan na to, mga managing partners na to. Na, kapag naman yung mga managing partners nagkaroon ng tie sa kanilang voting, the final decision shall be decided by the partners owning controlling interests. So, kapag nagkaroon ng tie between the voting of the managing partners, yung final say will be from the partners owning controlling interest sa partnership. Now, paano naman sinabi? Merong mga managing partners, two or more. Pero, those managing partners shall not act without the consent of the other. Anong mangyayari? Well, kung kailangan ng concurrence of all necessary for the validity of acts, kasi kailangan ng consent ng ibang managing partners. Now, in the absence or disability of anyone cannot be alleged unless there is imminent danger or danger of grave or irreparable injury or partnership. Na kapag naman wala yung ibang managing partners, tapos nagkaroon ng instances or circumstances na kailangang mag-decide agad ng remaining managing partner, na kung saan pag hindi siya magde-decide, it will put the partnership in imminent danger or irreparable injury, he will be excused to make the decision para hindi magkaroon ng adverse effects sa partnership. Lastly, manner of management not agreed upon. So, walang inassign na managing partner. Basta lang sinabi na magkakaroon ng partnership. So, paano nila i-manage yung partnership? Well, dito, all partners are agents of the partnership. And unanimous consent is required for alteration of immovable property. So, paano pag nagkaroon ng disagreement?
Well, if refusal of partner is manifestly prejudicial to interest of the partnership, court intervention may be sought. Meaning, kapag yung refusal ng isang partner is all about the interest of the partnership, is all about the well-being of the partnership, pwedeng mag-intervene yung korte. Pero pag hindi in the interest of the partnership, hindi pwede mag-intervene yung korte. Kasi, bakit siya mag-refusal? Hindi naman for the benefit of the partnership at the first place. Now, other rights and obligations na kailangan na napapataw sa mga partners. Una, si right to associate another person with him in his share without consent of other partners. Ito yung sasabi nating sub-partner kanina. Kung saan, shinare niya or in-associate niya ang ibang tao sa interest niya sa partnership. Like for example, yung kita na malilisip sa partnership, pwede niyang ibigay sa sub-partner. Next is right to inspect and copy partnership books at any reasonable hour. So, being the partner, he has the right to see the books of the partnership and copy such partnership book. Third is that the right to a formal account as to partnership affairs even during existence of partnership. So, kailangan niyang malaman lahat ng mga pinagagawa ng partnership considering the fact that he is a partner at the first place. Now, if is wrongfully excluded from partnership business or possession of its property by its co-partners, if right exists under the terms of any agreement as provided by Article 1807 and whether other circumstances render it just and reasonable. So, anong apat na to? Meaning, kapag itong apat na to, nandyan, individually, or ito nandito, or ito nandito, the partner can enforce his right to a formal account as to partnership affairs, even during the existence of the partnership. Pangapat naman na other rights and obligations na meron ng isang partner, duty to render on demand true and full information affecting partnership to any partner or legal representative of any deceased partner or any partner under legal disability. Meaning, disclosures lang. And lastly, duty to account to the partnership as fiduciary. As we know, fiduciary, yung relationship nila is based on trust and confidence. So, yan yung mga obligations ng partners among themselves. Now, pumunta naman tayo sa obligation of partners with regard to third persons. Because obviously, in order for a partnership to earn profits, it needs to engage in businesses with third persons. Now, the first obligation is every partnership shall operate under a firm name. Persons who include their names in the partnership name, even if they are not members, shall be liable as a partner because basically they are partners by Estoppel, representing themselves as partners even though they are not partners in a partnership. The second obligation is that all partners shall be liable for contractual obligations of the partnership with their property after all partnership assets have been exhausted, whether by pro rata or subsidiarily. Meaning, if the partnership has already dissolved, that in the liquidation of partnership, it is not enough to satisfy the obligation, then the partners themselves shall be liable up to the extent of that obligation to satisfy those obligations, especially those general partners. Then, whether pro rata man yan or subsidiary. The third obligation is the admission or representation made by any partner concerning partnership affairs within scope of his authority is evidence against the partnership. Meaning, kapag yung isang partner ni-represent niya or ni-admit niya ang kanyang sarili concerning the partnership affairs na kung saan it is within his scope to do so, then it is an evidence against the partnership. Meaning the partnership can be held liable. The partnership can be held accountable because it was done within the scope of his authority, within the scope of the authority of the partner who made the admission, who made the representation. Now, the fourth obligation is that the notice to partner of any matter relating to partnership affairs operates as a notice to partnership. Ito yung general rule. na kung saan yung notice na binigay sa isang partner in relation to partnership affairs, it is considered as a notice to the partnership itself, to the other partners. That is a general rule. Kaso may exception. And yung exception na yun is in case na may fraud. Like knowledge of partner acting in the particular matter acquired while a matter. Second is that knowledge of the partner acting in the particular matter then present to his mind, and knowledge of any other partner who reasonably could and should have communicated it to the acting partner. The fifth obligation naman is that partners and the partnership are solidarily liable to third persons for the partner's tort or breach of trust. The sixth liability is liability of incoming partner is limited to, ito yung mga newly admitted partner na na-discuss natin kanina. Now, ano yung extent ng kanyang liability? Well, first, since newly admitted partner siya, his share in the partnership property for existing obligation. So, yung kinontribute niyang capital or other stuff sa partnership to the common fund, yun lang yung share niya or yun lang yung liability niya when it comes to the existing obligation. Hindi siya magiging liable personally for those existing obligation. Kung ano lang yung kinontribute niyang share sa partnership. Now, when it comes to the subsequent obligations, yung after na siyang na-admit as a partner, yung subsequent obligations na yan, yung personal shares niya or yung personal properties niya will also be liable. So, intindihan nyo, dito sa existing obligations na kung kailan naging newly admitted partner siya, partner siya, yung obligation niya doon o yung liability niya yun, doon, for that particular existing obligation, is only up to the shares he contributed to the partnership. On the other hand, doon sa mga subsequent obligations, yung mga obligations na na-incur ng partnership after he was admitted, not only he is liable for the shares he contributed, but also he will be held liable personally kapag hindi na-satisfy yung mga subsequent obligations na yun. The seventh obligation is creditors of partnership preferred in partnership property and may attach partner share in partnership assets. Meaning, kapag nare-liquidate na ang partnership, isa-satisfy mo na yung credit ng mga creditor, yung liability sa mga creditor, bago maka-receive ang mga partners. Satisfy mo na yung claims ng creditor. The eighth obligation is that every partner is an agent of the partnership. Now, ano yung mga powers ng partner kapag agent sila ng isang partnership? Well, acts for carrying on in the usual way. Tandaan nyo, usual way of business of the partnership. Ito yung normal operations. Kapag yung acts was carried in the usual way of the business, every partner is an agent and may execute acts with binding effect even if he has no authority, generally. Pero kapag yung third person has knowledge of the lack of authority, then it is not accountable. The partnership has no responsibility over that. If the third person knows that the partner who carried the acts of the partnership in the usual way of business has no authority to do so, then it is not binding to the partnership. Pero kapag yung third person has no knowledge about that, then it is binding to the partnership. Kasi hindi na yan magiging suspicious. The mere fact that it is carried out in the usual way of the business, in its normal operating way. Na kapag naman, on the other hand, ito yung mga nangyari, not apparently carrying in the operating of the business, meaning, ang business is, nagtitinda kayo ng tinapay, tapos biglang nagbenta ng lupa yung partner in the name of the partnership, then it is not a usual way of carrying business. Ito, stick of dominion of ownership. Hindi wala kang karapatan over that. Assigned partnership, interest of creditors, disposed goodwill, etc., etc. Kapag ito yung mga nangyari, it will not bind the partnership unless it is authorized by the other partner. Meaning, kapag ito pinerform ng isang partner, ito yung mga kinds of transactions na kung saan carried out not in the usual way of the business. Ito yung hindi normal ginagawa sa isang business, hindi ito normal operations. Hindi ito binding sa partnership. Binding lang ito kapag nag-inauthorize ng ibang partners. Now, acts in contravention or a restriction on authority. Ginawa niya yung pinagbabawal. Ano yung mangyayari? Partnership not liable to third person having actual or presumptive knowledge of the restriction. Meaning, kapag alam ni third person na walang authority, na alam ni third person na pinagbabawal yung nangyari, hindi magiging liable ang partnership. Pero, kapag hindi niya alam, well, magiging liable ang partnership. Kasi, good faith si third person. Now, effects of conveyance of real property belonging to the partnership. So, ano mangyayari kapag binenta? Kapag transfer yung ownership ng real property na pagmamayari ng partnership? Well, depende sa senaryo. Unang senaryo is that the title in partnership name and it was conveyed in partnership name. Well, the conveyance passes the title of the partnership. Pwedeng yung title ng property napasa. Pero pwede itong ma-recover. Paano? Conveyance was not in the usual way of business. Meaning yung transfer is not within the normal is not within the normal operations of the business, or the buyer had knowledge of lack of authority. Kapag ito present, pwedeng ma-recover yung property even though the title was transferred. The second scenario naman kasi is that if the title is in the partnership name, kaso yung conveyance, kaso yung transfer was made in the partner's name, hindi sa partnership name, but rather in the partner's name. Ano mangyayari? The conveyance does not pass the title, but only equitable interest, kung ano lang yung interest ng partner. Unless conveyance was not in the usual way of business, or the buyer had knowledge of the lack of authority, then kahit equitable interest man yan, walang mapapasa. The third scenario naman kas is that if the title in name of one of more partners, conveyance in name if partner or partners in whose title in name of one or more partners, meaning papag under the name of one or more partners yung title sa property. Then yung pag-transfer sa property is in the name of the partner or partners in whose name the title stands. Ano mangyayari? Conveyance passes the title but partnership can recover. Kasi kita nyo dito, yung title ng property belongs to one or more of the partners. Then yung mga partners na to, kinonvey, transfer yung property, transfer yung title. So, ang effect niyan, conveyance passes the title. Kasi, all of the partners whose title is under their name agreed to that. So, the conveyance passes the title. But, since it is prejudicial to the partnership can recover. Pero marirecover niya lang yan kapag yung conveyance was not in the usual way of business, meaning hindi ito under sa normal operations niya, or second, the buyer had knowledge of lack of authority. Kapag ito existing, gaya sa dalawang ito sa taas, pwedeng ma-recover ng partnership yung property. Kahit na it is under the title of the partners and it was agreed by these partners to transfer or to convey that property. But since it is prejudicial to the partnership, meaning masamang epekto nito sa partnership, may masamang epekto ito sa partnership, si partnership pwede niyang i-recover. Generally, pero ito, pag pwede niyang ma-recover, basta it was conveyed not in the usual way of business, or the buyer had lack of authority, had knowledge of the lack of authority. Now, punta naman tayo sa fourth scenario. Title in name of one or more or all of the partners or third person in trust for partnership, conveyance executed in partnership name. If in name of partners, then ang mapapasa lang yung equitable interest. And last scenario, title in name of all partners, conveyance in name of all partners, conveyance will pass title. Kasi the title was under the name of the all partners. Then, yung all partners nag-agreed na ita-transfer, na i-convey yung partners na yung property, well, automatic, all conveyance will pass title. walang prejudicial kahit kanino. Kasi all partners agreed eh. Tapos all partners pang ang nagmamay-ari dyan, ang may title over that. Well, conveyance will pass the title. Smooth. Now, partner by Estoppel. Ito yung mga, by words or conduct, he does any of the following. Directly represents himself to anyone as a partner in an existing partnership or kahit na non-existing partnership. Or indirectly represents himself by consenting to another representing him as a partner in an existing partnership or in a non-existing partnership. Basically, ang ginawa ni partner by Estoppel, pinagmukha niya, pinakita niya na partner siya sa isang partnership kahit na in fact hindi siya partner, whether yung partnership na yan is existing or non-existing. Basta, he represents himself na, uy, partner ako sa ganito. Pero in fact, hindi talaga siya partner. Now, kailan magiging liable itong manlolokong to, itong Estoppel na to? Elements to establish liability as a partner on ground of Estoppel. Kailan siya magiging liable? First is that if the defendant represented himself as partner or represented by others as such and not denied refuted by defendant. Meaning, siya mismo, pinakita niya or nirepresent niya ang sarili niya as a partner. Or kapag pinayagan niya, explicitly man yan or implicitly, yung ibang tao na i-represent siya o ipakita na partner siya. Yan yung first requisite. Second, plaintiff relied on such representation. Meaning, ito si plaintiff, siya yung nagreklamo. Na kung saan, naniwala siya na yung naging decision niya was based on that representation. And with that, nagkaroon ng damage on his part. So, naging liable itong si Estoppel. And third, the statement of defendant not refuted. So, kapag ito yung mga requisites na nangyari, yung mga elements, magiging liable yung partner Estoppel, partner by Estoppel. Kasi niloko niya yung ibang tao. And yung ibang tao na yun, which relied on that representation, nag-incur ng damages, magiging liable si partner by Estoppel. Now, anong mga liabilities in Estoppel? All partners consented to representation, the partnership is liable. Kasi parang naging meron itong existing partnership, tapos alam nilang isang taong to, nire-represent niya ang sarili niya sa partner to that partnership, tapos they consented on that. Well, because they consented on that, the partnership itself will be liable kasi all the partners consented eh. Now, paano naman kung no existing partnership and all those represented consented? Now, walang partnership at the first place. Pero yung nagpa-represent, nag-consent sila, pumayag sila. Not all partners of existing partnership consent to representation. Ito namang sa second na to, merong existing partnership. Pero, hindi lahat nagbigay ng consent para mag-represent. Ano yung magiging liability? Person who represented himself and all those who made the representation are liable pro rata or jointly. Meaning, yung nag-represent sa sarili niya and yung mga pumayag sa representation na yun, magiging liable. Dito naman sa third scenario, no existing partnership and not all represented consented. Meaning, wala talagang partnership at the very first place and yung mga nagpa-represent, hindi nagbigay ng consent nila. Dito naman, merong existing partnership pero wala ni isang partner from that existing partnership ang nibigay ng consent nila to be represented, then yung magiging liable lang is yung taong nag-represent sa sarili niya at the first place na nag-represent na partner siya. Siya lang yung magiging liable. And those who made consented or representation shall be separately liable. Now, pumunta naman tayo sa assignment of interest in partnership. Assignment is subject to three conditions: made in good faith, for fair consideration, after a fair and complete disclosure of all important information as to its value. Now, ano magiging rights ng assignee sa isang assignment? Kasi ang assigner dyan yung isa sa mga partners. Kung saan, ni-assign niya yung interest niya sa partnership, and usually itong interest na to, yung mga profits, na kung saan pag nagka-profit ang partnership, ibibigay niya kay assignee. So, ganon. So, ano mga rights ng isang assignee? Get whatever the assigner or partner would have obtained such as the profits, avail usual remedies in case of fraud in the management, ask for annulment of contract of assignment if he was induced to join through any of the vices of consent, meaning niloko siya, yung VIMFU, kung naalala nyo. VIMFU, ano yung VIMFU? Violence, intimidation, mistake, fraud, or negligence. Undue influence, yun. And lastly, demand an accounting, pero only in case of dissolution. Yan yung mga rights ni assignee. Kapag inassign ng isang assigner or partner yung interest niya sa partnership. And usually, yan yung profits. Eh, kailan to nangyari? Like for example, may utang si partner sa isang third persons. Tapos yung ginawa ni partner, inassign niya yung interest niya sa partnership, particularly the profits, na kung saan, kapag nagka-profit yung partnership, yung profits na marireceive niya, yung share niya, yun yung ipamimigay niya para dun pambayad ng kanyang utang. Usually, yun yung example. Now, lastly, pumunta tayo sa responsibility ng partnership sa partners. So, ito lang. Maikli lang. To refund the amounts disbursed by partner in behalf of the partnership plus corresponding interest from the time the expenses are made, loans and advances made by a partner to the partnership aside from capital contribution. So, ibig sabihin, may utang si partnership sa partner. So, si partnership, being a separate legal entity, a separate juridical entity from the partners, babayaran niya yun. That is an obligation of the partnership. Kumbaga, si partnership naging debtor. Si partner naging creditor. Ito yung loan to partnership, yung sa ATVAC natin. The second is to answer for obligations partner may have contracted in good faith in the interest of the partnership business. Kasi take into consideration, it was for the beneficial of the partnership. Yung na-contract na obligation in the interest of the partnership business. And it was done in good faith. So, yung partnership yung magiging liable. And lastly, to answer for risk in consequence of its management. So, yan yung last part ng responsibility ng, ito yung last part ng, anong topic to? Ito yung last part ng obligations of the, ito yung sa chapter 2, obligations of partners. Pumunta naman tayo sa chapter 3, kung saan, nag-operate na yung business. Then, after ng operation, magkakaroon na ng dissolution and winding up. Mag-liquidation na sila. So, ano tong topic na to? So, dissolution and winding up. So, ano bang dissolution? Well, ito na yung change in the relation of the partners caused by any partner ceasing to be associated in the carrying on of the business. Partnership is not terminated but continues until the winding up of partnership affairs is completed. Meaning, so basically, ang dissolution, kapag yung isang partner or because of certain circumstances na sira na yung relation or not necessarily sira, nag-end na yung relationship between them as partners, that relationship at partners, then there's already a dissolution. Bakit? Kasi at the first place, yung partnership na yan is a fiduciary relationship between the partners, trust and confidence. Na kapag nawala yung isang partner dyan, nasira na kumbaga yung relationship na yun. So, kailangan nang mag-dissolution ng partnership. Madi-dissolve na yung partnership. Nawala na yung binding between the partners. Pero, yung operations ng business, hindi pa terminated. Bakit? Kasi kailangan pa nitong mag-wind up. Kailangan pa nitong ayusin yung affairs nito. So, ano yung wind up or winding up? Process of settling the business or partnership affairs after the dissolution. So, ito yung kailangan pang ayusin para yung mga liabilities, yung mga obligations, maayos para walang problema. Then, termination. Ito na yung point when all partnership affairs are completely wound up and finally settled. It signifies the end of the partnership life. Dito, wala na. End na. Kaput. Nag-end na yung any rights, any obligations, any interests, any relationships among the partners. Wala na talaga. Now, ano yung mga causes ng dissolution? Ano yung mga reason bakit ito nangyayari? Well, marami yan. Ito sila. Law. Una, without violation of the agreement between the partners. And under that is termination of the definite term, meaning may fixed term or nakagawa na nila yung particular specific undertaking. The second was is by the express will of any partner na dapat it was acted in good faith and there was no definite term or particular undertaking specified. Meaning, ito yung partnership at will na kung saan nawala na yung will, so magdi-dissolve na. The third one, or letter C, is that by the express will of all of the partners who have not assigned their interests or charged them for their separate debts, either before or after the termination of any specified term or particular undertaking. Meaning, yung mga partners na mismo nag-decide, hindi lang isa. Lahat sila na i-dissolve na yung partnership, na i-end na lang nila yung partnership relations between them. Letter D, by the bona fide expulsion of any partner from the business in accordance with conferred by the agreement. Ito, basta walang violation sa agreement and within the powers of the partnership na tanggalin yung isang partner, it is under this one. Basta walang violation sa agreement. Now, the second cause of dissolution is kapag nagkaroon ng contravention of the agreement between the partners where the circumstances do not permit a dissolution but under any other provisions of this article by the express will of any partner at any time. Ito, meron ng contravention sa agreement. Meron ng violation sa kanilang agreement. And with that, by the express will, pwedeng ma-dissolve yung partnership. The third cause naman is by any event which makes it unlawful for business to be carried on or for the members to carry it on for the partnership. Let's say, sa isang state sa Amerika, let's say Colorado, nagtayo ka ng partnership with the other people and yung binibenta nyong product is marijuana. Then, yung legislative ng Colorado biglang ni-reverse yung previous bill nila, previous law nila, na kung saan ngayon binalik nila sa pagiging illegal yung marijuana. So since yung business nyo is all about selling marijuana, tapos biglang binago, biglang unlawful, then wala nang object, wala nang purpose yung business nyo, hindi na kayo makapagbebenta. So that will cause the dissolution of the partnership. Fourth is the loss of specific thing promised by partner before its delivery. Ito pinag-usapan natin kanina. Death of any partner. 6. Insolvency of a partner na bankrupt. 7. Civil interdiction of any partner. Ito yung mga rights niya, especially managing his assets, managing his person, was taken by the law or was taken from him. And 5 is the decree of court under Article 1831. Ito, yung korte na mismo ang nag-declare na yung partnership na yan dissolved na. Now, ano mga grounds para sa dissolution ng partnership by decree of the court? Well, ito given. 6 sila. Partner declared insane in any judicial proceeding or shown to be unsound mind. Incapacitated. Incapacity of partner to perform his part of the partnership. Incapacitated din. Third is the partner guilty of conduct prejudicial to business of partnership. Like, for example, ito yung kanina. Industrial partner performing or engaging in other business, or the capitalist partner engaging in other business, engaging in business that is the same kind with the partnership. Those are acts prejudicial to the business of the partnership. So, pwedeng ma-dissolve yan by court decree. Pangapat naman is willful or persistent breach of partnership agreement or conduct which makes it reasonably impracticable to carry on a partnership with him. Meaning, yung defendant o yung tao o yung nireklamong partner, pasaway, parating bina-violate yung partnership agreement na kung saan it came to the point na hindi na viable o hindi na practicable na makipag-engage pa sa partnership sa kanya. So, by court decree, dissolved. The fifth one is business can only be carried on at a loss. Ito yung mga on the verge of declaring bankruptcy. Malalaman sa general banking laws, sa mga insolvency law, sa RFBT nyo pagdating sa review. Basta ito, carried at a loss, kailangan na ma-dissolve ng partnership by declaration, boom. And lastly, other circumstances which render dissolution equitable. Now, upon application by purchaser of partner's interest, ito, bibili nyo yung partner internship. After termination, specified term particular thing, or any time may partner to when interest was assigned, charging order issued, additional notes na lang to kahit i-disregard nyo. Now, pumunta naman tayo sa effects of dissolution. Siyempre, pag nag-dissolve ang partnership, may mga effects na mangyayari yan. Una, i-discuss natin yung authority of partner to bind the partnership. Given, as we know, a partner is an agent of the partnership for which some of his acts his acts may bind the partnership in some obligations, some transactions. Now, the general rule sa authority ng partner to bind the partnership is that authority of partners to bind partnership is terminated. Kapag na-dissolve na yung partnership on the process of dissolution na, wala nang karapatan ng mga partners na i-bind pa yung partnership sa mga transactions, business. Bakit? Kasi hindi na mag-ooperate yung partnership. Kaya this authority is terminated, with the exception of wind-up of partnership affairs or complete transactions not finished. So, ito lang yung exception na kung saan pwede pang i-bind ng partner yung partnership, pero for the purpose lang of winding up the partnership affairs and complete transactions not finished, kasi ito yung mga actions or ito yung mga acts na kung saan it is in relation to closing or terminating the partnership. Kailangan mo nang isettle lahat ng affairs bago i-terminate completely ang partnership. Now, qualifications tayo with respect to partners, binding ng partners. Authority of partners to bind partnership by new contracts, ito yung sasabi natin kanina, is immediately terminated when dissolution is not due to act, death, or insolvency of a partner. Tandaan nyo, yung authority ng partner para i-bind yung partnership sa new contracts is immediately terminated kapag yung dissolution hindi dahil sa act, death, or insolvency ng isang partner. Paano naman kapag yung dissolution is due to act, death, or insolvency? Then, partners are liable as if the partnership was not dissolved. When the following, siyempre may conditions yan, when the following concur. If cause is act of partner, acting partner must have knowledge of such dissolution. Ibig sabihin, aware yung acting partner na dissolve yung partnership. And second, if cause is death or insolvency, acting partner must have knowledge or at least man lang na notice. Now, punta naman tayo sa with respect to persons not partners. Partner continues to bind partnership even after dissolution in the following cases. Now, ito, biting, pwede pang i-bind yung partnership, pero sa following cases lang to. Transaction in connection to winding up partnership affairs or completing transactions unfinished. So, ito na yung kanina. Ito yung sa exception. And second, transactions which should bind partnership if not dissolved when the other party or obligee in situation 1 had extended credit to the partnership prior to the dissolution, had no knowledge or notice of the dissolution, meaning binding pa rin. Binding pa rin as if hindi na-dissolve yung partnership in these particular exceptions. Nag-extend ng credit prior to dissolution. Basically, completing transaction to eh. Had no knowledge or notice of dissolution, meaning for him, actively operating pa rin yung partnership. Sa situation 2 naman, did not extend credit to partnership, had known partnership prior to dissolution, had no knowledge or notice of dissolution or fact of dissolution, not advertised in newspaper, journal, security in a place where partnership is regularly carried on. So, ito yung isa with respect to persons, not partners. Pero, ito lang yung partner continues to bind the partnership even after dissolution. Ito, sa letter B, ito na yung instances na kung saan yung partner cannot bind the partnership anymore after dissolution. Ito, pwede pa. Basta, itong mga exceptions na to, itong mga conditions na to was satisfied. Winding up, completing transaction, sa situation 1, nag-extend ng credit, tapos walang knowledge ng prior dissolution. Sa situation 2, hindi nag-extend credit, alam na may dissolution. And the second one, and had no knowledge, notice, dissolution of facts, and newspaper justification, where the partnership is regularly carried on. Pagdating kay letter B, first partner cannot bind the partnership, hindi na talaga pwede. Una, where dissolution is due to unlawfulness to carry on with the business, except in winding up affair or partnership affairs to settle yung mga natitirang affairs. So, naging exceptions pa sa to the exception. And lastly, when partner has become insolvent. Ano pa? Under letter B, na hindi pa pwedeng ma-bind yung partnership after dissolution. Ito, where partner unauthorized to wind up partnership affairs except by transaction with one who, o dito, siyempre, yung partner na hindi authorized mag-wind up, mag-settle ng affairs ng partnership, wala siyang karapatan i-bind pa yung partnership after dissolution. Pero may exceptions dyan. Ito yung mga transactions with persons who, situation 1, had extended credit, pero walang prior knowledge. Situation 2, ito yung mga hindi nag-extend ng credit prior to dissolution, may knowledge ng dissolution, and ito, yung newspaper carried in the place, regular carried on. So, ulit natin. Ito, with respect to kay letter A, pwede pang i-bind yung partnership sa dissolution basta may winding up affairs, completing transactions, basically settling affairs. Pagdating naman kay letter B, hindi na talaga pwedeng i-bind yung partnership kapag yung reason bakit nagbi-business yung business ng partnership is nagiging unlawful na, except kapag winding up of partnership affairs, settlement of obligations, kumbaga. And kapag yung partner is insolvent or kapag yung partner is unauthorized, except yung transaction. Daming exceptions, di ba? Pumunta naman tayo sa next effects of dissolution, which is the discharge of liability. Now, dissolution does not discharge existing liability of partners except by agreement between the partner and himself, person and partnership continuing the business, and partnership creditors. Now, rights of partner with dissolution not in contravention of agreement. So, ano mga karapatan ng partner na kung saan yung dissolution is not in contravention of agreement? Well, apply partnership property to discharge liability of partnership, meaning to settle the obligations, to settle the liabilities of the partnership. Then, any apply surplus kung may matira man, if any, to pay in cash the net amount owed to partners. Now, paano naman kapag yung dissolution ng partnership was because of contravention of agreement, violation of agreement, kumbaga, ano yung mga rights ni partner? Well, first, paano si partner who did not cause dissolution wrongfully, ito si innocent partner, ano yung mga rights niya? Una, apply partnership to discharge liabilities, siyempre. Then, kung may surplus man, ibabayad sa mga partners. Then, third is indemnity for damage caused by the partner guilty of wrong dissolution. Ito, indemnity, rights for damages to. The fourth one is continue business in same name during agreed term. And lastly, possess partnership property if business is continued. Now, ano naman yung karapatan ng isang partner na nag-cause ng dissolution because of his wrongdoing? Ito si partner who wrongly caused dissolution. Ano mga rights niya? Tandaan, rights ang pinag-usapan dito, hindi ang kanyang obligations. Ano ang mga rights niya? If business not continued by others, meaning nag-stop na talaga, apply partnership property to discharge liabilities of the partnership and receive in cash his share of surplus less damages. Kasi may kasalanan siya may wrongful act siya. So, kailangan niya mag-pay ng damages. So, ang marireceive niyang cash is net of the damages he caused for his wrongful dissolution. Now, paano naman kapag yung business was continued by the other partners? Ano ang rights niya? Well, have the value of his interest at time of dissolution ascertained and paid in cash or secured by bond and be released from all existing future partnership liabilities. Now, pumunta naman tayo kay rights ng isang injured partner where partnership contract is rescinded on ground of fraud, misrepresentation by one party. So, ito yung partnership contract na kung saan nag-rescind siya, nagkaroon ng rescission because mayroong fraud or misrepresentation. So, anong karapatan ng injured partner? Anong karapatan ng walang kasalanan? Well, rights to lien on surplus of partnership property after satisfying partnership liabilities. Rights to subrogation in place of creditors after payment of partnership liabilities. And lastly, right of indemnification by guilty partner against all in partnership interests, partnership debts and liabilities. So dito, as we can see, yung mga interest niya to satisfy his ownership to the partnership. And dito naman, since nagkaroon ng wrongful doing through fraud or misrepresentation, yung taong may kasalanan, yung guilty partner, shall be liable for damages. He will indemnify the injured partner. Pumunta naman tayo sa settlement of accounts between partners. Ito naman, between the partners. Sa asset of partnership, partnership property, including goodwill and the contribution of the partners. Na paano ang order of application of assets? Ito, familiar kayo, ad back pa lang, liabilities, undergrad. Alam nyo na ang order na to. Una, sa partnership creditors, third parties. Next, sa partner as creditors, yung mga loan to partnership. Kung natatandaan nyo, loan to partnership or loan from partner. Sa advac, kung natatandaan nyo, partners as creditors. Next is partners as investors, return of capital contribution, and lastly, partners as investors, yung shares of profits if meron man. Then pumunta naman tayo sa when business of dissolved partnership is continued. Kinontinue daw kahit na dissolved na. Parang ito yung excuse me. Parang ito yung nag-dissolve na first place, yung then yung mga natirang partner, nag-decide sila na i-continue yung business, then yun, i-continue nila. Kaya sayang ang kita business yan. Ano yung mga mangyayari? Or ano yung mga effects ng dissolution? Well, the first, yung creditor of old partners are also the creditor of the new partnership, which continues the business of the old one without liquidation of the partnership affairs. Meaning, natanggal yung isang partner, whether due debt man yan, insolvency, or expelled, tapos yung mga natirang expulsion, tapos yung mga natirang partners, nag-decide sila na i-continue yung business kasi sayang, di ba sabi ko? Kasi, kita yan So, kapag na nangyari, continue business without liquidation, yung creditors ng old partnership, creditors ng new partnership. Now, the creditors have an equitable lien on the consideration. Lien, explain ko na last time, ito yung parang rights mo over something. Rights or interest over something. Yung something yan, whether ano man, property, things. Lien on the consideration paid to the retiring or deceased partner by the purchaser when retiring deceased partner sold this interest without settlement with creditors. And lastly, rights if retiring or estate of deceased partner to have the value of his interest ascertained as of the date of the dissolution. Ito, siyempre, may ownership or may shares sa partnership yung nag-retire na partner o yung estate ng namatay, which is the partner. Siyempre, kailangan niya ma-receive yung shares niya. So, to have the value of his interest ascertained as of the date of dissolution, kung kailan siya nag-retire, kailan siya namatay, and to receive as ordinary creditor, the value of his share in the dissolved partnership with interest or profits attributable to use of his right at his option. Now, sino yung mga taong authorized to wind up the partnership? Una, partners designated by the agreement, sinong pinili nila. In the absence of agreement naman, all partners who have not wrongfully dissolved the partnership. And lastly, legal representative of last surviving partner. Now, pumunta tayo sa last part ng ating discussion for partnership, which is limited partnership. Na yung mga previous discussion natin sa topic na to, we are just pertaining to the general partnership. Yung mga general na nangyari sa isang general partnership. Dito sa chapter 4, may particulars kasi ang isang limited partnership that is very different from a general partnership. So, ano bang characteristics ng isang limited partnership? Well, this is formed by compliance with statutory requirements. Kasi may mga certain requirements pa na kailangan ma-satisfy para maano tong limited partnership na to. It is more contingent kumbaga. Then, one or more general partners control the business. Then, one or more limited partners contribute to the capital and share in the profits, but do not participate in the management of the business and are not personally liable for partnership obligations beyond their capital contributions. Ito, na-discuss na natin to kanina. Na si limited partner, as opposed kay general partner, itong si limited partner, contribution lang of cash or property ang kanyang labot, ang kanyang importance sa partnership. Hindi siya pwedeng mag-participate sa management. Kay general partner yan. Fourth is that may ask for the return of their capital contributions under conditions prescribed by law. And lastly, partnership debts are paid out of common fund and the individual properties of general partner. Now, anong difference ni general and limited partner or partnership? Si general, gaya nating dinidiscuss pa rin kanina, personally liable for partnership obligations na kung saan pag hindi na nasatisfy ng partnership properties yung liabilities, yung obligations, then pwedeng kunin ng mga creditors yung remaining part sa personal assets ni general partner. Pero pagdating sa isang limited partnership, yung contributions ni limited partner, yun lang yung pwedeng kunin ng mga creditors. Yun lang yung liability niya up to the extent of his contribution. Hindi pwedeng kunin ng mga creditors yung kanyang personal property. So, yung dinidiscuss natin kanina pa is all about the general partnership. Kasi pagdating kay limited partnership, yung liability ng isang limited partner is only up to the extent of his capital contribution. Hindi pwedeng kunin yung kanyang personal properties. Now, kay general naman, when manner of management not agreed upon, ito, na-discuss natin kanina, when it comes to the management of the partnership, kapag walang agreement, all general partners have an equal right in the management of the business. They are agent of the partnership. Pagdating naman kay limited partner, wala talaga siyang participation sa management ng partnership. Si general ang bahala dyan. Ito, contribution of cash, property or industry, yan ang pwedeng gawin ni general. Pero pagdating kay limited partner, contribution of cash or property lang. Hindi niya pwedeng i-contribute ang industry. Kasi limited lang siya eh. Limited in such a sense na wala siyang participation sa management. Eh, yung nagpa-participate sa management, usually yan yung mga may industry. Yung mga industrial partner, usually sila yung nagpa-participate sa management. Kasi limited, hindi siya pwedeng participate sa management. So, hindi siya pwedeng mag-contribute ng industry. Now, proper party to proceedings by or against the partnership, si general yan, si limited, hindi sa proper party, interest not assignable without the consent of other partners. Pagdating kay limited partner, interest is freely assignable. Si general, name may appear na partnership. Sa limited, name must appear in the firm name. Bakit? Kasi as we know, and usually pag yung isang partnership is limited, nilalagay yan sa pangalan ng partnership. If I remember correctly, it is LTD dot blah 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 name limited LTD. Meron yung LTD sa pangalan ng partnership. Now, bakit yan nilalagay? Para yung mga third persons maging aware na itong partner na to is limited lang yung liability niya up to the extent of his contribution, na hindi pwede habulin yung kanyang personal properties. Kaya nilalagay yung pangalan niya sa pangalan ng firm para maging aware yung mga third persons na hindi pwedeng kunin yung kanyang personal properties to satisfy the remaining obligations. Next is the prohibition against engaging in business. Ito yung na-discuss natin kanina. Si general partner, prohibited siya to engage in other business that are the same kind with the partnership unless it is consented by the partners. Pero kapag other kind of business, pwede siyang mag-engage kahit walang permission ng partner. Pagdating naman kay limited partner, walang prohibition against engaging in any kind of business. Hindi niya kailangan mag-consent to engage in any kind of business. Now, retirement. para kay general, retirement, death, and insolvency, insanity of general partner, dissolves the partnership. Kay limited naman, does not have same effect, rights transferred to legal representative. Kaya sabi ko sa inyo, yung diniscuss natin kanina, puro kay general partner lang yun. Kasi si limited partnership, meron siyang sariling characteristics, sariling anong magandang term? Characteristics na lang, nakalimutan ko yung term na yun eh. Now, ano mga requirements para sa formation ng isang limited partnership? Well, una, certificate of articles of the limited partnership must state the following. Ito. And, ito, dami, di ba? And, kailangan ng certificate must be filed with the, yung certificate must be filed with the SEC. Kaya nga sabi dito, formed by compliance with statutory requirements. And as we know, sa general partnership, by mere agreement lang, meron ng partnership. Yung mga subsequent lang, yung mga statutes of frauds, compliance with immovable property, mga additional requirements lang yun na hindi kailangan para mag-form ang partnership. Kailangan lang yun when certain things na kinontribute sa partnership and kailangan yun sila para sa pag-operate ng partnership. Pero in general, gaya ng discussion natin kanina, by mere consent lang, ang general partnership, it is already formed. May contract na. Pero pagdating kay limited partnership, may statutory requirements pa. Ito, tapos kailangan pang i-file kay SEC, kay Securities and Exchange Commission. Now, when general partner needs consent or ratification of all limited partners. Now, sa general partner, kailangan niya ng consent, kailangan niya ng ratification for certain acts. Now, ano-anong mga acts to? Well, first, ito yung do any act in contravention of the certificate, do any act which would make it impossible to carry on the ordinary course of business, confess judgments against partnership, possess partnership property, assign rights in the specific partnership property other than for partnership purposes, admit person as general partner, admit limited unless authorized, continue business with partnership debt, retirement, insanity. So as we can see here, ito yung mga klase ng acts na not in the usual way or not in the normal operations ng business. Ito yung mga acts na not in the usual way of business or not in the normal operations. So because of that, kailangan niya ng consent, kailangan niya ng ratification from the limited partner. Now, ano ang mga specific rights ng mga limited partners? Well, familiar. Rights to have partnership books kept at principal-based business, inspect at a reasonable hour, demand true and full info, all things affecting partnership, full disclosure, kumbaga, formal account of partnership affairs, ask for dissolution and winding up, receive shares of profits with compensation of income, and receive return and contribution provided the partnership asset are in excess of all its liability. So, halos same lang or same lang talaga sa general partnership. Now, ano yung mga requisites to return of contribution to limited partner? Well, ito yung mga requisites. All liabilities of partnership have been paid off. If not yet paid, at least sufficient to cover them. Then, the consent of all members have been obtained. So, with that, certificate is cancelled, amended as to set forth the withdrawal or reduction of contribution. So, kapag itong nasatisfy, pwede nang i-withdraw or kunin ni limited partner yung kanyang contribution sa partnership, yung kanyang capital na kinontribute. Now, ano naman yung mga liabilities ng isang limited partner? Yung liabilities towards the partnership is first, for the difference between his contribution as actually made and that stated in the certificate as having been made. So, ibig sabihin, pag may kulang sa kanyang contribution, kailangan niya yung masatisfy. The second one is for any unpaid contribution which is agreed in the certificate to make in the future time. Same lang. Kung may kulang sa contribution, kailangan niya yung bayaran. Now, being a trustee for the partnership, ano naman ang kanyang liabilities? Well, first, for the specific property stated in the certificate as contributed by him but which he had not yet contributed. So, kailangan niya ibigay yung kanyang contribution. Second, specific property to the partnership which had been wrongfully returned from him, kailangan niyang isauli. And third, money or other property wrongfully paid or conveyed to him on account of his contribution. Now, kapag nag-dissolve na yung isang limited partnership, ano yung priority ng dissolution ng assets? Well, first, kung makikita nyo, mas mahaba siya compared dun sa previous order of distribution sa general partnership. Dito 6, doon 4 lang. Now, ano tong 6 na to? Those due to creditors, including to limited partners. Those due to limited partners in respect of their share in profit compensation. Those due to limited partners of return of capital contributed. Now, pag nasatisfy na si limited partner, those due to general partner other than their capital and profits, those due to general partner in respect for the profits, and those due to general partner for return of capital contributed. So makita nyo, mas priority si limited partner. Pangalawa kay creditors. Pag nasatisfy na si creditor, yung loans from limited partners, yun na yung next is satisfy. Then yung shares of profit and commission, then yung return of capital. Tsaka lang pag ito na-satisfy, tsaka lang bibigyan si general partner sa kanyang capital profits, respect to profits, other than capital profits, sa respect of profits, and then return of capital. That is the end of our discussion with partnership. Medyo mahaba yan siya pero chillax lang. Bye-bye!